All rise. Court of Appeals Division 1 is now in session.
Thank you. Be seated. Good morning, everybody. Now's the time set for oral argument in cause number 1 CACC 17-0002, Suncity Homeowners Association versus the Arizona Corporation Commission. For everybody's information, these proceedings are being both audio and video recorded to the best of our ability, if it's working this week. So barring any unforeseen problems, we are hoping that you'll be able to critique yourself on YouTube in a couple of weeks. Counsel, each side is going to be entitled to the normal 20 minutes. We would ask that you respect that time period. The timer located on the podium will let you know how much time you have left. And for the appellant's benefit, if you wish to save any portion of your time for rebuttal, please let us know. We will try not to suck it all up. Please, we have reviewed the briefs. We've conferenced the matter this morning, so we are well aware of the facts and the issues attendant to the argument. We want you to know that so you can better determine how to use your time. However, ultimately, your reserving of rebuttal is up to you. Counsel, when you come to the podium, I would ask that each of you state your name and who you represent. And with that, appellant's counsel, you can begin.
Thank you, Your Honor. Good morning, and may it please the court. I am Robert Ellman for the appellant, Suncity Homeowners Association. And I'd like to reserve 2 minutes of my 20 for rebuttal, if that's possible, Your Honor. This decision rests on the fallacy that you can change the cost of service of separate infrastructure systems by viewing them as a whole and counting them together. But customers in the Sun City District can never cause the costs of Anthem's separate infrastructure or anyone else's. To treat them as if they can...
Be real clear about what you're saying there, please. Be real clear about what you're saying cannot happen. I'm intrigued by your notion that this can't be moderated, modulated, balanced out. I'm intrigued if that's what you're saying.
Yes. The principle is that the cost causer is the cost payer. If you're living in the Sun City District, you have your own separate infrastructure. You've got a Tellison wastewater plant. You've got your own pipelines and pumping stations. Anthem is a completely separate infrastructure. It's impossible for someone in Sun City to cause costs in Anthem for that reason.
Even the creation of a new system, putting in an entirely new facility, that wouldn't. If we're talking about if this was brought into one entity, right? If these were brought into one entity, you don't think that the costs in one might be shared by all or should be shared by all?
Well, again, Your Honor, it depends entirely on the physical plant, because if you built a new facility that connected Sun City customers with Sun City West customers and Anthem, then you'd have a basis for doing that because they now create part of those costs. If you simply lump them together in one district, it's like giving 2 tables at a restaurant one check, and no matter what they ordered, you make both of them responsible for half of the bill because the waiter has decided to view tables holistically. Well, that's great news for the lobster table, but the people at the grilled cheese table are going to tell the waiter, we should only be responsible for the food we ordered. And the waiter's answer under this regime is, well, you did. I did not repudiate pay for what you ordered principles. I simply view tables as a whole. Clearly, that cannot stand. It's also antithetical to the well-established rate-making principles that the Commission has followed up until now, and that is simply that the cost causer has to pay his or her reasonable share of the costs that they cause. You can't disconnect them without creating disparity. And parity in a rate-making context is not the same rate, it's the same rate of return, which is to say the profit margin. So if EPCOR is making 7% profit on people in Sun City, it also is supposed to be making 7% profit on people in Agua Fria and Mojave and the other districts.
Mr. Ellman, I have really a preliminary question about our role in all this. Let's say you persuade us that this approach is untenable. Two of us were on a panel that resulted in an opinion in the RUCO versus Corporation Commission, and Judge Downey wrote the opinion. And in that case, the Corporation Commission is charged by our Constitution with determining fair market value of an entity when they're rate making. And the Corporation Commission had adopted a procedure that pretty clearly did not include a fair market value evaluation. And we held that way. The Supreme Court said the Commission has essentially plenary authority in determining how it meets its constitutional obligations, and that it was not our role to critique their rate making. I mean, essentially, they said even though RUCO had pointed out some deficiencies in the procedure, that we had to defer to the Commission's ultimate determinations. Now, how do we have a role in determining or in effectuating any of what you're telling us?
Well, the Commission has a degree of discretion. It's fairly broad, but whenever...
Which we acknowledge.
Of course, and as we do, but that discretion ends where discretion exercised on an error of law begins, or where a decision is based on a clearly erroneous fact pattern. Now, notwithstanding the case you're describing, less than 2 months ago, this court adjudicated a case under similar circumstances. I'm referring to Freeport. And they said very clearly, explicitly in that case, in paragraph 18, it's the last sentence, that you must have parity unless you have sufficient record-supported reasons to deviate from that. And even if you do, you have to stay as close to parity as you can, which is to say the same rate of return, which I referred to earlier. Suncity's rate of return is now 63%. The rate of return of the other former districts is negative, and that means, among other things, that Suncity customers are paying for 100% of Epcor's profits in all of those wastewater districts combined. That is not only unreasonable, but it's discriminatory. So you have at least 2 violations, and they're of constitutional magnitude.
So, counsel, just to go back to standard review real quick. So, on that point, is our review de novo as to whether it was discriminatory and to whether the rates were just and reasonable?
Well, it's the same principle that I would offer in any other case, Your Honor, to the extent that what you're addressing is a legal determination. It is de novo. It always is, as a matter of course. And you have a number of different decisions here to contemplate. And I'm not asking you to decide what the proper rate is, and I concede that rate making is a complicated economic subject. But here it's been reduced to a fallacious formula, and if you were to follow this viewpoint in other cases, consolidation and a uniform tariff would result every time. Now, I know the Commission says that it applied cost causation principles, but that's impossible. You can't reconcile it with the facts. The structure that they've adopted has no element whatsoever of cost causation. The connection to rate and cost has been broken completely. There's no effort to stay as close to parity as possible. And of course, if your construct results in a uniform tariff and consolidation in every case, it necessarily cannot be considering cost causation. And that's what happened here. Now, they say...
In your brief, I believe you've asserted that our review of this matter should be strict scrutiny.
Yes, Your Honor.
How do we strictly scrutinize a rate decision of the Corporation Commission?
Well, excuse me, you would have to say that the new rate structure is necessary to fulfill a compelling reason, and it does it as narrowly as possible. Now, even if it were compelling, I just pointed out the breadth of this. They're not attempting to stay as close to parity as possible. So I think that's how it would probably play out here. But this case doesn't come down to the standard of review, Your Honor, because this fails under any standard standard. It is manifestly arbitrary.
You've reflected in your briefs that strict scrutiny is the standard of review.
Correct.
It's not. I mean, that's not what we should be doing anyway, regardless.
That is the standard. The standard review is strict scrutiny under Kenyon and the other cases. I have a duty to tell the court, after reviewing the case law, what the standard is supposed to be. And the case law tells me that any right guaranteed by the Arizona Constitution, implicitly or explicitly, and these are explicit, is reviewed under strict scrutiny. There's no exception for this particular provision, so that's the standard. However, if you do what you do in the non-rate cases where you don't have those constitutional provisions, you would still have to find this arbitrary, capricious, unlawful, and unsupported by the facts. The Commission says here that they follow cost causation because they don't have to view it in the same traditional narrow way that they've always viewed it before, but in fact they do. What they're referring to is their own precedent, and in their own cases they say that the rate structure they've created here, and I'm quoting, is defective, it's inequitable, and it violates a basic principle of rate making. Even if you could find some sustainable logic in this new approach, you still can't apply it indiscriminately from case to case. And what you have in this decision at page 202, and encapsulated beautifully in paragraph 97 on page 226 of this decision, which if you read nothing else, please read that paragraph. What's been done here is an abandonment of cost causation under anyone's viewpoint. If you look at the case law, you look at the treatises, and as I said, under the Commission's own prior decisions. If you apply that new viewpoint here and nowhere else, it's arbitrary. And when you read the decision, all the Commission says is that we don't have to view cost causation narrowly or traditionally. They don't draw a distinction between other cases and this one. They simply say that different cost causers can become one cost causer if you view them as a whole. And again, that is a fallacious supposition.
The Commission did assert or consider that the Sun City District would require pretty substantial capital improvements in the future. Is that correct?
They did assert that, yes.
Is that not borne out by the record?
That is not borne out, Your Honor. That's actually addressed in the reply brief at pages 23 and 24, but I can explain why. It's not only wrong, but it's unsupportable, because the figures that EPCOR's own experts derived for future capital investment put Sun City's future capital investment at something like 35%, when in fact they are 48% of the customer base. So they're not going to be incurring a disproportionately high amount of expenditures in the future. And the error is doubled here because everything else the Commission relies on is speculative. You only have two components in a wastewater system. You've got the treatment and you've got the conduits. And the treatment is done by Tolleson. And again, EPCOR's own expert said, with respect to anticipated capital improvements, that they don't know if the amount is going to be $1 or $100 million, and, quote, it's a bit of a mystery to us. Secondly, the big ticket item here for capital improvement is clay pipes, and you know that whether they're necessary and on what schedule and at what cost is all in dispute. Well, the Commission can certainly find a fact there, but it doesn't. In this 230-page decision, the last mention of clay pipes is on page 82, where the Commission is summarizing what various parties said. It refers to future costs in Tolleson at the bottom of page 2 and the top of 202 and the top of 203. But it doesn't make a finding on the big ticket item, the clay pipes. It's not mentioned anywhere in the analysis or the findings of fact. So that basis is entirely speculative. If for no other reason, it would have to go back for that.
Even if it were not speculative, to what extent does the authority support that you can encompass include future costs in a rating increase?
You can't, Your Honor. It's unlawful. Arizona rate setting is based on historic costs. When you look at the formula everybody agrees on, for what the revenue requirement is, it depends on the rate base, which is using an historic test year and then current expenses, and that's how you derive the rate. More of that is future looking. Future investment is captured in future test years. You make that capital investment and it depreciates, along a continuum, and that's where higher rates come from, and that's what rate shock is. And again, that's actually defined in the Freeport case. Rate shock is the sudden increase in cost and rate, therefore rate, necessary to maintain parity, to keep that profit margin even among all customers in the same class.
So are you suggesting that any suggestion that Suncity West, for instance, might be incurring a $60 million expense in the next 8 years would be pure fabrication? Because they have no way of knowing what that facility is going to be like 8 years from now?
I'm not saying that, Your Honor. I'm sure that the numbers they're giving you are, offered in good faith. I presume that. And it's actually, I think, a different number for Suncity West. But
yeah, I think I added some numbers up. It may not be my skill set.
I think the Commission added some numbers up the same way. And that's.
But is that possible? Can they go forward and assess costs that are going to be expended over the next 6 or 8 years and say we got to get ready for those?
They can do that to a degree. It's permissible under this SIB you're reading about, and that's a separate proceeding. It's not a full-fledged rate-making proceeding, but it does permit them to look forward, I believe, for 5 years and anticipate capital costs there. But the capital cost allocation does not in any way support what they're doing here, because they're equalizing rates, and Sun City actually anticipates lower capital investment, even under their own figures. So that can't be right. Judge Brown, did I answer your earlier question? Yes. All right. They also say that this can't be discriminatory because we're offering the same service at the same rate. That's not the formula. It's the same service for the same rate under like circumstances. And according to every expert on utility rate making, cost of service is the single most important factor in determining a reasonable rate. We have wildly different cost of service here. Okay, so this is clearly not like circumstances under anybody's definition. The Commission also says that our deference is broad enough to capture this. It isn't, and I think I explained why an error of law trumps that. There's still a judicial backstop, and this Court and the Supreme Court have repeatedly vacated Commission decisions, and they've even criticized the sort of formulaic resolution of cases, as the Commission candidly admitted in their their answering brief. The deference is supposed to be based on their expertise in this most complicated of all economic subjects, but you here have a specious formulation, and you have another expert. RUCO is equally expert, and in fact the only thing they ever weigh in on are residential utility rates, and they strongly opposed this plan for essentially for the reasons I'm explaining right now. So in a set of circumstances like that, I think the basis for deference is in grave doubt, to say the least. Economies of scale barely merits mention. This is foisting $20 million more on Sun City over the next 5 years, so that people throughout the consolidated district can split a savings of $946,000 over the same time period. So that puts a tiny little cart in front of a gigantic horse. It's like telling a prisoner he's being paroled in the 19th year of his 20-year sentence, but he didn't commit the crime in the first place. The Commission holds the record up as evidence that it properly considered the factors in this case, including cost causation. It did not. The size of a record doesn't control whether you have analyzed the problem correctly. And this Court has had case after case with month-long jury trials where the verdict has to be vacated because there's an error in the jury instruction. The size of the record can't cure an error, and it can't ensure that your analysis was correct. I'd like to reserve the remainder of my time, please.
Thank you, counsel.
Good morning, Your Honors. May it please the Court, Naomi Davis on behalf of the Arizona Corporation Commission appellee. I would respectfully request to reserve 5 minutes of my time to provide intervener EPCOR Water Company with an opportunity to present.
So at the culmination of your statement, the water company is going to...
Provide a brief presentation if the Court is agreeable.
Now we know what to expect. Appreciate it. Thank you.
Thank you, Your Honor. The Commission's decision in this case allocated EPCOR's revenue recovery in a way that is just, reasonable, and in the public interest. Article 15, Section 3 of the Arizona Constitution grants the Commission full exclusive power to set rates, charges, and classifications with only the requirement that those rates, charges, and classifications be just and reasonable. With that outer limit...
Non-discriminatory?
Under certain circumstances, Your Honor, to the extent discrimination means charging customers within the same class different prices, the Commission has the discretion to determine that is appropriate.
But isn't that on the table here?
Well, the company, Suncity Homeowners Association, SHOA, brings its claim under Article 15, Section 12 of the Arizona Constitution, as well as ARS 4334 A and B. And those provisions are actually directed at public service corporations and prohibit them from unreasonable discrimination or from providing rates that provide a benefit to one customer and a detriment to the other. Or from discriminating between parties who are receive substantially the same service. The Commission's rates and rate design, as it's already set, is presumed to be just and reasonable.
And how do we apply strict scrutiny to that?
You don't, Your Honor. The standard of review in this case is statutorily determined, and it puts the burden of proof on the party challenging the Commission's decision. The application of strict scrutiny would flip that burden of proof around. It would put the burden on the Commission to demonstrate why its decision, here its choice of rate design, is narrowly tailored to meet a compelling government interest. And that burden shifting is incompatible with the statute ARS 425401E and the interpreting authority of Commission decisions, that those decisions are given the presumption of constitutionality because of the Commission's unique constitutional-based authority, unless, of course, that decision is found to be unreasonable or unsupported by substantial evidence. That argument also fails, in addition, because Article 15, Section 12 prohibits public service corporations from discriminating in charges between persons or places for alike and contemporaneous service. That prohibition...
Person or place?
A person...
What's a place under the Constitution?
Under this provision, the Commission would interpret that to mean different places as geographic.
Less than the state of Arizona?
Less than the state of Arizona?
Less than the entire state?
Yes, within the state.
So we can't have one giant water company that encompasses all the private water companies. We can't have just one.
We could have, if the CCNN that is granted to the company by the Commission, which is itself a determination that's presumed to be just and reasonable, it's up to the Commission to decide how to allocate the revenue requirement in a manner that is fair and equitable among the Commission's among the utilities customers. And they're going to...
EPCOR, perhaps a better example, is EPCOR buys a water company in Concho, Arizona, which is 15 miles west of St. John's, if you don't know. It's northeastern Arizona. Yeah, so Concho Water Company. Probably 100 customers. I don't know. Anyway, small company. If they buy that, then is that ripe for consolidation? Should it be consolidated? Because, or can it be legally, even though it's 200 miles away, and those folks are paying maybe $15 a month?
With no further information, that sounds like that would raise some serious issues as to the justness and reasonableness.
And where I'm going with this, is this, you characterize this case as run-of-the-mill, basically, or is this groundbreaking?
This is not groundbreaking, Your Honor.
Isn't this the first, would this be the first reported decision in Arizona, though, that affirms a consolidation of sewer treatment plants or water districts?
An unreported decision, Magruder, decided in 2016, recognized that when the Commission decides to take up the matter of consolidation is a matter for the Commission's discretion. To the extent that this decision affirms that proposition, this could be the first reported decision. But it confirms or affirms previously decided principles, which is that the Commission's discretion in rate making is an exercise of its exclusive legislative authority and expertise. And if it determines that a consolidation of different wastewater districts is in the public interest, that determination must be given deference.
And going back to standard review, I understand your position that strict scrutiny does not apply, but are there any legal questions here before us? Or are we purely looking at all of this? Is the evidence is there? If the evidence is there, game over. Get out our stamp and stamp affirmed.
Well, I believe there are three legal issues. The first is the strict scrutiny standard, which we say does not apply. The second is, has the Commission allowed a rate design to exist that discriminates among customers who are in fact similarly situated? It has not. And the third issue is, do the Commission's factual findings, which are given deference, amount to reasonable level that constitutes substantial evidence in support of its decision? And counsel brought up the recent Freeport decision. In that decision, the Court of Appeals recognized that even if there is an alternative rate design that appears viable, or even if this court found it preferable, if there is substantial evidence that supports the Commission's choice, that choice must be affirmed.
What form of discrimination might we be looking for that would indicate impropriety on the ACC's part? You said as long as it's not discriminatory. What form would that discrimination possibly take so we would know if we saw it?
The Commission would maintain that none of the express provisions of Article 15, Section 12, or ARS 4334A or B are present here. And I would contrast with an example of rate discrimination in which that was found. That was the case of the town of Wickenburg versus Sabin, in which case the Arizona Supreme Court found that the town had arbitrarily charged a customer a $50 deposit based on the type of dwelling that he lived in, and failed to charge the same deposit to individuals who lived in the same type of dwelling.
So there's dwelling discrimination? Is that what
Not dwelling discrimination, but discrimination in pricing and charges between customers who are similarly situated. That is what's prohibited by Article 15, Section 12.
So help me understand this. Before consolidation, is Sun City similarly situated with all the other four districts?
Your Honor, the Commission would maintain that, yes, it is similarly situated.
How?
They are within the same residential class that the Commission in its discretion determined was receiving the same quality of service, the same reliability of service, despite the fact that, yes, Sun City does have some of its flows treated by the city of Tolleson. There was no evidence provided in the record that demonstrated that that slight difference resulted in any kind of different service being received from the other districts.
What about the argument that their costs are substantially lower?
Within the same district of Sun City, if you broke it down to individual customers, there's going to be a certain level of subsidy occurring no matter what you do. A customer who lives 5 minutes from the wastewater treatment plant is going to cost the company less to serve than a customer who lives 20 miles from the treatment plant.
Based on what?
Based on proximity to that plant. And so it's going to cost the company less to serve one customer within the same district under certain circumstances than it will cost
Talking
them.
about laying down pipe.
Yes,
But
exactly.
is that what the Constitution is geared toward? The prohibition of discrimination is one neighbor versus the next neighbor on the amount of linear feet of pipe?
The Constitution simply says that public service corporations may not discriminate among similarly situated customers. And in this case, the Commission, in its discretion, determined that its residential class is comprised of individuals who are similarly situated, that its commercial class is a different class, not the same as residential, and that its bulk customers are different. And in support of SHOA's discrimination theory, SHOA primarily relies on a decision involving the Federal Energy Regulatory Commission, the Alabama Electric Co-op case. Although Showa relies heavily on that decision, the court in that case did not hold that FERC's application of the same rate to customers with different rates of return or costs of service was unlawfully discriminatory. The problem was that FERC did not consider the evidence or that argument at all. So the court remanded the decision so that FERC could consider it and use it as an aid in rate design. And then on remand, FERC determined that the use of the same rate was not discriminatory. Showa relied heavily on that failure to consider argument in its reply. But the record and the underlying rate case is 8 years in the making. The decision cited 12 different decisions in which the Commission considered consolidating versus deconsolidating EPCOR's different water districts. And at the outset of the case, the company, at the Commission's order, presented 3 different costs of service studies that showed what rates would be under a partially consolidated model, which the Showa advocated, and that was option 1. Option 2, a fully consolidated model, and option 3, which was a fully deconsolidated model based on plant alone, which no one advocated. Just because the Commission selected option 2, however, doesn't mean that it failed to consider option 1. Indeed, the Commission ordered the company to provide that information in the first place.
But didn't the Commission feel like it couldn't stay with option 1 because that would have been discriminatory against the existing customers?
Indeed, Your Honor, the Commission...
It's a catch-22 for the Commission?
It's not a catch-22, Your Honor, but the reason the rate case was brought the way it was is that there was a great disparity among residential customers. Agua Fria residents were paying $106 a month, set to go up to $122 a month for 7,000 gallons worth of water, whereas Sun City was paying $18 a month flat fee. They're receiving the same service from the same company. Billing is centralized, customer service is centralized, testing is centralized. They found that it was unreasonable to maintain this level of disparity between its residential customers. Council also cited RUCO for its position that this was not in the public interest, and RUCO is, of course, representative of the residential class. However, the decision cites the fact that RUCO conceded that Mojave, after Sun City, has the second lowest mean household income, mean home value, and mean household income for senior households, and has the second highest senior population, and that Mojave's rate would increase as a result of a partial consolidation model. RUCO conceded that the Agua Fria district already has a single tariff to cover 3 different geographic locations that are not physically interconnected. RUCO conceded that certain communities in the Agua Fria district are already paying more than their actual cost of service because they share a wastewater treatment plant with Sun City West. And RUCO conceded that the Commission does not strictly follow cost of service when designing rates, as commercial cost customers often subsidize residential customers, and low-income customers are subsidized by other ratepayers.
Council, I want to ask you a question about rate consolidation. On page 224 of the Commission's decision, under findings of fact, number 83 says, and I'm quoting, rate consolidation is generally consistent with the first 5 of Bond-Bright's 8 criteria for setting rates. Do you know what I'm talking about?
Yes, I do, Your Honor.
Okay. On pages 175 and 176, in footnote 266, the Commission lists the 8 principles. Principle 6 is about the fairness of rates, and Principle 7 is about avoiding undue discrimination. If Bond-Bright says that rate consolidation is generally consistent with the first 5, are we to read the Commission's finding of fact, number 83, as a concession that consolidation is both unfair and unduly discriminatory in this case under 6, 7, and 8?
Your Honor, no, the Commission would not concede that.
Why would they distinguish that it's consistent with 1 through 5 but not 6, 7, and 8?
6, 7, and 8, including the provision of fairness?
6, 7, and 8.
Yeah, the fairness and avoidance.
Fairness, avoidance of undue discrimination, and efficiency of the rate classes.
Your Honor, I believe as far as fairness, they may have been addressing the fact that for Sun City, there's no way of avoiding the fact that they're going to see a rate increase, and then that to them initially feels like they are receiving a detriment to the benefit of other classes.
So they're planning ahead.
They're planning ahead, that's right.
Mr. Ellman said there's no way they could do accurately.
And that's simply not supported by the evidence in the record. The company had an engineer testify that, as a initial matter, the company was already recovering costs of replacing collection mains in Suncity in its 2016 rate case, and it was already going to recover projects that were planned in that 2016 rate case for the next 12 months following the rate case. Its engineering witness testified exactly what projects were intended to cost millions of dollars, and Suncity had the highest level or numbers as far as infrastructure needs out of any of the other districts. And I can cite you to where in the decision that is. You'll give me a moment. In fact, I don't have it with me, but I'd be happy to provide it.
Do you have a response to Mr. Ellman's statement that I was, not me personally, but apparently my understanding of the incurring of possibly up to $60 million in the next 8 years? Was that part of the consideration for the Suncity West introduction into this consolidated group?
The fact that that was part of the consideration, absolutely, is future capital expenditure.
That 8 years out.
Yes, they actually had it determined, I believe, 5 years out and then 10 years out.
I was thinking it was 4 and 4, but maybe, okay, if it's 5 and 5, is that an appropriate methodology?
I believe so, Your Honor, based
Rates today.
For rates today, no, that $38.12 that was set to be the rate is designed to recover costs that have already been incurred, and up to a year after the rate case, which is permitted as post-test year plant. But they can plan ahead. I'm sorry?
So the $60 million has already been incurred?
It has not been incurred. That's what's being planned. They're allowed to plan ahead. They're not allowed to recover for it yet. And that has not been subsumed in the rate. With this court's permission, I'd like to provide the remainder of my time to the company.
Thank you, counsel. Tell you what, you know, when good things are happening, you just don't want to see them end. Counsel, why don't you take 5 minutes? Counsel, with the appellant, we're going to give you 5, and I think with that we'll finish up. Is that fair to everybody? Go ahead.
Yes, Your Honor. Good afternoon, I believe. Michael Hallam from the law firm of Lewis, Roca, Rothgerber, and Christie, on behalf of the intervener, Epcor Water Company, the utility whose rates are at issue in this case. May it please the court. The first issue I wanted to address were some comments made by Mr. Ellman that I wanted to clarify. There were references in his discussion of the commission avoiding its own precedent. Importantly, in the rate-making context, the commission acts in its legislative capacity. So the concept of precedent just does not apply. The commission, of course, sometimes looks at what it's done before, but it's not bound by any prior decision. So in each case, the commission's fond of stating and reminding parties that it takes each case on a case-by-case basis. And
but does it establish methodology?
It can establish policies, which it does, and there's a process for doing that. It can look to prior cases to establish methodology, but to state that in a prior case there was separate districts, and so that's precedent, is just not correct. The commission can always revise those districts. In fact, it does so quite often. So that's, I just wanted to clarify that point. As the briefs made clear, this...
So in a couple of years, if things aren't working out, then Suncity can be deconsolidated from the rest of the group?
Judge, they certainly could. There would be nothing to prevent the commission from doing that. You know, we talked, or you've talked with counsel about these projected costs. If for some reason those didn't come to fruition, and there were other factors that at that point in a future rate case 10 years from now, it appeared that the consolidated district was not appropriate, then the commission has that jurisdiction, it has that ability to, and that authority to relook at those issues. And in fact, you know, I think there's been citations, I forget which brief, but there was a consolidated district here, Anthem and Agua Fria, that were ultimately deconsolidated, which led to the issues that we're here today to address, because it led to some unreasonable rates. So the commission always has that ability. And with that segue, this proceeding began with a commission order in which Epcor was ordered to provide revenue requirements with class cost of service studies based on full consolidation, which is what the Commission adopted, full deconsolidation, and also continuation of the existing standalone districts. As noted in the briefs, this order arose after multiple rate case proceedings in which the Commission examined consolidation and which parties addressed those issues. All of these customers in this district are EPCOR customers. All of these customers receive wastewater service from EPCOR. Some are residential customers who are now in a residential class. Some are commercial, and some are bulk service customers. This case involves the company's residential customers who all receive the same wastewater service from EPCOR. Ultimately, the Commission determined that a monthly flat rate of $38.59, and this is after a 5-year phase-in, was just and reasonable for all of these residential customers. Although
whether you live up where it was earlier referenced up in northeastern Arizona, or you live in Suncity West, it is fair and appropriate that in 5 years they would all pay the same rate.
that is what the Commission determined. And that's, as you probably know, there are multiple consolidated utilities, APS, TEP, and that's...
What's that first one? I've never heard of that.
whose customers all pay the same rate. Whether you live in Phoenix, whether you live in Douglas, you're paying the same rate, and you benefit from those economies of scale. Although EPCOR was not required to take a position on the issue of consolidation, and regardless of the outcome, its revenue requirement and its revenue recovery would be the same, it determined and strongly believes and still believes that consolidation is in the best interest of its customers. There's been some talk about the Alabama Electric Cooperative case, and that's a case that SHOA puts quite a bit of reliance on. And SHOA's real argument is that discrimination exists when different customers are treated the same. That's the core of its argument. That's not what happened in the Alabama Electric case. Those were two different classes of customers who were arguing discrimination. But it's asking this court to find a right for where different customers who are treated the same, that leads to discrimination. And I just wanted to speak to the implication of the reliance on that strained reading of that decision. As I just mentioned, there are multiple utilities in Arizona who have consolidated single tariff systems. Reliance on the argument put forth by SHOA would allow neighborhoods in different areas to bring a claim of discrimination, saying, well, I'm closer to the transmission line, so my costs are less. I live in a more dense area, so my costs are less, so I'm being discriminated against. These consolidated systems are long-standing, and as I said, include APS, TEP, and many others. Same would be true for EPCOR's existing customers. I know I've used my time, so if I have about 2 more sentences, so if you'd like me to finish.
Give us 2 sentences.
Okay. The same would be true for EPCOR's existing customers. Customers in Verrado, who are part of the Agua Fria District, would have a claim for discrimination because customers in Russell Ranch are more expensive to serve. These examples highlight the flaws and the concerns raised by appellant's claim. And with that, I'll conclude.
Thank you.
Thank you.
I'll just clarify, just to be fair, we gave you an additional minute and a half. The idea was to give you 5 minutes, so if we give Mr. Hellman like up to, just go to 3 minutes, if that's okay. Is that okay?
That'll work.
Want to keep it fair.
No telling what you could do with that extra minute and a half. Mr. Hellman.
I'll speak as quickly as I can, Your Honor. Commissioner Burns, in his dissent, made the point that he favors consolidation when it's necessary to assist a small, struggling water company that may not be viable on its own because it can't make the capital investment. If you look at those commission decisions cited by Verrado about prior consolidation, they all involve circumstances that do not exist here, including different districts or different systems that were already interconnected, systems where the consolidation did not create a subsidy for anyone, so on and so forth. That's a very different scenario, and so is a customer in eastern Arizona and western Arizona being served at the same rate by the same utility when you're talking about an electrical grid, because Arizona is part of an 11-state system that can draw power from anywhere. The Commission also erred in characterizing the way that Sun City was putting that, saying, well, it's not as if they're all... characterize Sun City's argument as those can be consolidated because they're all based on one plant, and they're not. Of course they're not, but they generate part of that cost.
Doesn't that argue, though, for EPCOR and other utilities that want to follow this process being given as great a latitude as possible? I mean, isn't that what you're saying, is they all have different circumstances, they all have to be able to reach some goal, and you can't measure them all by the same?
Not at all, Your Honor. What I'm saying is far narrower than that. Okay. Is that the reasons for consolidation in some circumstances, such as natural gas and electric, don't exist in a wastewater scenario where we have separate systems, because people in East Arizona cause part of the same cost that people in Western Arizona do when they're drawing power off the same grid or from the same place. If Sun City runs out of wastewater capacity, it can't borrow some from Anthem. That's the difference. They're treating them as if they're the same. And that, class versus resident distinction in the Alabama cooperative case is absolutely irrelevant to this principle. It's the same cost causation principle they're discussing, and it's not just Alabama Electric. It's all the treatises. This is groundbreaking, Judge Brown. We have never seen the formulation in paragraph 97 at page 226. That is out of nowhere, and it has to be dealt with. EPCOR is a public service company, so I don't understand that point. And finally, no system ever goes house by house. That would be absurd. What you have to do in every case is make sure that people in the same district paying the same rate are generating the same costs. That's why you can't take separate systems and do what they're saying you can do here. Okay? Those houses, the pipes may be different lengths to get to them, but they're all drawing off of the same infrastructure. They're all causing part of that cost. They're not causing any part of costs in the other systems. So for these reasons, Your Honor, I will ask you to correct this mistake and save the people in the Sun City District tens of millions of dollars that they should not have to pay. Thank you.
We do enjoy a live presentation. And it gives us a chance to actually get feedback when we have the question before us. So thank you very much for that. Thank you for your presentations. We have certainly listened to what you had to say. We are going to take this matter under advisement at this time. We will make our decision in due course. Thank you. We're adjourned.